We will now recognize Mr. Messenger.
Chairwoman Wilson, Ranking Member Wahlberg, members of the subcommittee, thank you for the opportunity to appear before you today. I practice labor and constitutional law for the National Right to Work Legal Defense Foundation, advocating for individual employees in both the private sector and the public sector. And that includes representing Mark Janus in his case, Janus versus AFSCME, before the U.S. Supreme Court. In Janus, the Supreme Court held it was unconstitutional under the First Amendment for the government to compel employees to subsidize a union's speech without their consent. As a result of Janus, an estimated 5 million public employees were freed from forced fee requirements and now have the right to choose whether or not to support a union. But while public sector workers now enjoy this freedom, many private sector workers do not. And in particular, those private sector workers not fortunate enough to work in the nation's 27 right-to-work states can still be forced to support a union against their will, even though their public sector brethren cannot. Now, this inequity can be rectified by Congress passing a National Right-to-Work Act, which would extend right-to-work protections to all employees. With the National Right-to-Work Act, both public sector employees and private sector employees would enjoy the freedom to choose whether to support a union. Unfortunately, some propose to make an inequitable situation even worse by stripping private sector employees who enjoy right-to-work protections of those protections. A prime example is the Protecting the Right to Organize Act, HR-2474, which permit unions to force private sector workers to pay compulsory fees, notwithstanding state right-to-work laws to the contrary. That act represents a step backwards. In the wake of Congress should seek to expand worker freedoms, not to curtail them. But while Janus freed public sector workers from forced fee requirements, many are still subject to forced representation requirements. Under monopoly bargaining laws, workers are required to accept a union as their exclusive representative for speaking and contracting with the government over certain public policies, irrespective of whether the individual employee approves or not. In other words, the government is dictating who speaks for employees in their relations with government. And as a result, the individual worker is stripped of his ability to speak for himself or through other associations of his or her choice. Now, the Supreme Court in Janus recognized that this form of government-compelled association substantially restricts non-members' rights and, quote, causes significant impingement on associational freedoms. And in fact, it turns the democratic process on its head. Under monopoly bargaining laws, instead of citizens choosing their representatives in government, the government is choosing representatives to speak for its citizens. Even Franklin Delano Roosevelt, who enacted the National Labor Relations Act, opposed public sector monopoly bargaining. But at a minimum, monopoly bargaining is a fundamentally flawed idea that Congress should leave up to the states of whether or not they should politically collectivize their own employees. Currently, state labor relations are governed not by federal law, but by state law. And some states, such as Virginia and North Carolina, do not allow monopoly bargaining at all. And several other states, after suffering the negative consequences of handing union officials too much artificial political power, have been moving to reform their laws. As these states are moving to correct the situation, Congress should stay out of the way and not make their job harder. And in fact, the 10th Amendment requires that Congress respect state sovereignty on this matter. Under the 10th Amendment, the federal government cannot interfere with state governance by dictating both its states regiment their employees into mandatory advocacy groups, and formulate their public policies based upon bargaining with those advocacy groups. Such interference with how states formulate their own public policies would violate basic principles of federalism and would not survive a legal challenge in the courts. Thank you for your opportunity to testify today, and I look forward to answering any questions you may have.
Thank you, Mr. Messenger.
I guess I would ask you this question. Do right-to-work, secret ballot elections, or employee privacy impact workers' rights to organize? And second, why are these protections so important for workers?
Thank you for the question. To answer them in reverse order, the reason they're so important is the First Amendment guarantees every individual the choice to choose with whom they associate. So the government shouldn't be in the business of forcing any individual to associate with a union or any other advocacy group against their will. And to the extent the government does decide to force individuals to submit to monopoly representation, at the very least, it should be done pursuant to a democratic process in which the individuals are guaranteed the right to a secret ballot vote, where they can make their choice in the privacy of a voting booth, as opposed to being forced to make that choice in the presence of a union organizer. And that goes to the second question with respect to giving out employees confidential information. The information that some of these bills seek to require disclosure of is personal to those employees. It's personal email addresses, personal phone numbers. It's a violation of that individual employee's privacy to compel the disclosure of that information to a third party that that individual may not want anything to have to do with. And then when you couple them together with the disclosure of information and the lack of secret ballot protections, you're putting together a very coercive process.
Takes away their choice.
And if I could also go back to answer your first question with respect to secret ballot elections, another important part of a secret ballot is that the result is respected of that election. Under HR 2474, the PRO Act gives the NLRB the authority, if employees vote against union representation, to overturn that result if the NLRB believes it doesn't reflect employee free choice and impose the union on those employees that they just rejected. And so I think that the PRO Act, in that way, even though employees were given the right to vote, it means little if their voice isn't ultimately respected.
So, Mr. Messenger, did any public sector bills being discussed today help prevent instances of fraud and corruption that might go on that, here we're talking about the taxpayers, okay? I represent the taxpayers. And what do you see out there as far as instances of government union corruption negatively impacting our taxpayers?
Yes, I didn't see anything in HR 2474 that would prevent union corruption. In fact, by reinstituting forced fee requirements and overriding state right-to-work laws, HR 2474 would facilitate that kind of corruption. Because when employees have the choice to decide whether or not to support a union, they can hold the union and its leadership accountable by withdrawing their financial support if the union is mismanaging the assets. However, if
State Senator wanted to say something, and I got 5 seconds. Go ahead, sir.
You have one.
That's an excellent point. And when corruption is uncovered, it's because of federal LM reporting requirements in the private sector. Most states do not have the equivalent in the public sector.
Thank you for that. Mr. Messenger, the recent Janus decision allowed government workers in non-right-to-work states to opt out of forced union dues. Is there any data on how many workers in those states have actually chosen to not pay those agency fees?
Well, we know one thing is that all the forced fee payers, which were individuals who were not union members who were being forced to pay these compulsory fees against their will, were almost all entirely freed in the wake of Janus, because Janus was unequivocal that the government cannot take these individuals' money for union fees without their affirmative consent. But the next question becomes, how many individuals who were union members, because they now had the right to choose whether to support a union, decided to drop out? And the numbers on that are still really undetermined. They're just rolling in. Tomorrow is the 1-year anniversary of Janus, so there's really not hard numbers yet on how many exercised that choice. But I want to emphasize the most important thing isn't how many exercise that choice to be union members or non-members, but the fact they have that choice. Prior to Janus, they didn't have the right to choose whether to support a union. The government and union officials forced them whether they wanted to or not. And now they have that choice. And even if few exercise it, it's still a very important principle.
Mr. Messenger, Democrats' labor agenda this Congress has been about imposing the will of union bosses on unwitting states, employers, employees, and others in order to reverse the decades-long decline in union membership. Why might it be in the interest of union bosses to undermine right-to-work, secret ballots, and employee privacy? How do these proposals relate to the original intent of the National Labor Relations Act?
Well, all three of those issues, the compulsory unionism with the compulsory fees, the taking away of the secret ballot election, and the disclosure of private information, are all intended to facilitate allowing union officials to exert their power over individuals who may not want to associate with that union. And it perverts the original intent of the National Labor Relations Act. Well, or as amended by the Taft-Hartley Act, I should say, which was to facilitate employee free choice, not to have a one-sided pro-union type agenda. And in fact, you could see that through the legislative history. When originally enacted, the National Labor Relations Act was rather one-sided, but Congress corrected that in 1947 with the Taft-Hartley Act to provide that employees have the right to refrain from supporting a union and to protect them from unfair labor practices caused by union and union officials. And so there is some balance at present within the structure of the National Labor Relations Act. But bills, like the PRO Act, are meant to upset that balance and very much skew things back against individual employees.
Mr. Messenger, one of the reforms included in Missouri's collective bargaining reform is a requirement that unions stand for periodic recertification elections, as we've talked about. To your knowledge, does any such requirement currently exist for private sector workers under NLRA?
It does not exist. In fact, most private sector workers have never had the opportunity to vote on union representation. I believe a recent study showed that over 90% have actually never voted for the union that currently represented them because the union was voted in or card checked in many, many years ago, sometimes even decades ago. And there's never been an election because under the National Labor Relations Act, unless employees can affirmatively put together a 30% petition within a very narrow period of time, they're precluded from demanding an election. And there's a variety of tactics that are used, such as merging bargaining units and such, that make it extremely difficult for employees to decertify, making the need for recertification elections that much more apparent.
Mr. Messenger, Democrats seek to impose binding arbitration on both public and private sector collective bargaining negotiations, essentially empowering unaccountable bureaucrats to determine workers' contracts and employers' costs. What problems might this create for employers' financial stability as well as the unique needs of employees?
Well, there's two issues. The first of which is that, going through the binding interest arbitration process could result in terms that are disastrous for the employer. Under current collective bargaining law, an employer does not have to agree to any particular terms. It has to bargain to impasse, but doesn't have to agree to them. If you go to binding arbitration, suddenly the arbitrator is in control of important company policies that may control the fate of that company. And also, binding arbitration may upset the constitutional basis on which the National Labor Relations Act was upheld. When it was originally passed, one of the reasons it survived constitutional challenge is because it didn't force employers to enter into agreements with unions that bind their employees. If the arbitration would, of course, change that and potentially open the act up to legal challenge.
Madam Chair, appreciate this hearing, appreciate the witnesses, and I served in the state legislature in Texas for 8 years, and I happen to represent, I live in the highest per capita income city in North America with over 250,000 people, and as businesses come, and they primarily come from union states, and when they cite reasons they come, they talk about how Plano has great schools, how we're investing in roads, how we have a low tax burden. But another thing that is very consistently mentioned is we're a right-to-work state. And I think the success of my community, certainly the high per capita income is great, but also just looking at the employment numbers, since January 2017, we've created 620,000 jobs in Texas, and we have a 3.5% unemployment rate, which is the lowest it's ever been. So clearly what has worked for Texas, what's worked for my community, I hope that Congress can leave well enough alone and say, hey, they've got it right and they're doing a good job. But, and Senator, thank you for being here. I appreciate your service, and I know what it means to be a senator. It's great that you're being here. I never had to do that extra duty, so thank you for taking the time to be here from the Show Me State. But Mr. Messenger, I'm just going to ask you a very, very technical question about HR 1154, and it imposes, without imposing a penalty that strikes or illegal for public safety officers only when they, quote, will meet or measurably disrupt the delivery of mercies, close quote, and are, quote, designed to compel an employer to agree to terms of the contract, close quote. Based on your reading, does anything in HR 1154 prevent a government union from striking over a political or legislative issue? I mean, is there anything to stop them from striking, nothing to do with work, but they can strike over some kind of political issue or legislative issue?
I've noticed no such restriction in the law requiring or limiting what strikes can be over and preventing them with respect to political type issues.
Right. So, like, I mean, an example would be, I'm sure myriad examples, but obviously that creates a whole nother level which has nothing to do with work, right? I mean, I think we generally think of unions as being about work environment, pay, conditions, hours, things like that. And a lot of the benefits that we've discussed today have been about those things precisely. But this allows, quote unquote, politics to be involved and strikes to go based on politics.
Yes, and as the Supreme Court recognized in Janus, all collective bargaining in the public sector is political. I mean, ultimately, the union is trying to influence governmental policies, and even things like wages and such ultimately affect the public fisc and public services that can be provided. So in the public sector, all collective bargaining is political, which is one of the reasons the Supreme Court in Janus held that employees couldn't be forced to subsidize that advocacy.
So I guess what you're saying is you could see a strike that was purely political in nature and has nothing to do with actual work. I mean, the work conditions or the employer or hour or pay or anything like that. I mean, it could just be a purely political, and then the employee, the union member, is then kind of forced to go on a strike that in a political cause that they wouldn't even want to be part of.
Yes, and some of the testimony today, I believe, supports that. There's been the argument that collective bargaining, affects public safety. I think that's one of the justifications, for the bill which we're talking about. So we are talking about something that's political, ultimately, something that affects public safety, even in the opinion of those who advocate, for this bill. And so, yes, it's all political.
Well, and so I think when we think about our constitutional rights and something that the Bill of Rights is something very important, I think, to every American. In the First Amendment, we have the right to freedom of speech, right to freedom of association, 3 other rights. But compelling people to be part of an organization they don't want to be part of, and worse, compelling them to participate in political speech with something that may be an anathema to them, I think is a disturbing strike at the core of our democracy, at the core of this idea of fundamental of free speech, that we can say what we think and we don't have to worry about someone telling us what we're going to say and forcing us to go on a strike about a political cause that we don't support.
I agree. I mean, monopoly bargaining in the public sector involves the government mandating that a particular organization, a union, speaks for a group of workers whether they approve or not. And in my opinion, that infringes, on their freedom of association, including even if there is a secret ballot election. The Supreme Court said in West Virginia versus Barnett, the First Amendment exists to protect certain liberties from majority rule, and those liberties cannot be subjected to a majority vote. And so if each individual has the right to decide who represents them, who speaks for them in their relations with government, which they certainly do under the First Amendment, it's unconstitutional, in my opinion, to force individuals to accept a representative, even pursuant to a majority vote.
All right, thank you. And Madam Chair, you'll